So from time to time, we'll have a client come into our office. They've been in an accident, and the other party is claiming that they're not at fault because they had a seizure or something of that nature. The question is, who is at fault under those circumstances? When you've been injured in an accident, it's not your fault, but the other party says they're not at fault even though they failed to yield the right-of-way. Well, Alabama law says that under those circumstances, there may not be. It may be what's called an unavoidable accident. An unavoidable accident is one where there's not necessarily any negligence that caused the accident, but there's some other cause that was beyond the control of the parties involved. And in that situation, what happens is the party that failed to yield the right-of-way, if that's the claim, is the party that has the burden to prove that the accident was unavoidable, that they did not commit negligence, that they went unconscious through no fault of their own, or they had a heart attack, caused them to lose control of the vehicle, or they had a seizure. But that's not the end of the story, because if they're on notice of an impending incapacity that could cause them to lose control of the car, then that becomes the negligence that then becomes the reason for them to be liable for your damages. You start proving that case, you've got to prove that they were on notice that they had either epilepsy, let's say epilepsy for an example. If someone has epilepsy, they're on notice that they could lose consciousness at any time unless they are controlled with medication for some extended period of time that then allows them to drive with that condition that is controlled. If it's not controlled and they're aware of it, they can still be liable, even though they may not have consciously caused the accident. It's a complicated issue, but there is a legal remedy that allows you to recover under those circumstances.